I think it is inevitable that there's going to be greater and greater legislative action requiring operators to use produced and recycled water in order to drill, frack, complete, or recomplete wells. I think that's coming as fresh water continues to diminish, and it is a necessary resource. I think the requirements on reuse of water are going to increase. And so the value of that produced water is going to increase.
Welcome to the Land Department Podcast. The state of land and energy as we see it.
Brett, lithium is all in the news right now.
Oh, it's the new hot chick.
Yeah. We're continuing the conversation. We had Reagan Marble on before. Really interesting episode. Got a lot of feedback on it. Hopefully this one's an even bigger one. We've got Bobby with us. Welcome to the show, Bobby.
Glad to be here.
Yeah.
We got the much cooler and more complicated last name.
Yes.
That's right. That's exactly right.
That's the longer guy from San Antonio.
Yeah, it's hard. It's hard to get competition for hardest last name to pronounce, but man, especially when you read it, I think you might have me beat, Bobby.
It's a tough one, but
you got it. Unless you're a good old South Texas Pollock, and then it's no big deal.
Unless you're a South Texas Pollock, and some lucky girl will go from Smith to Biedrzycki one of these days. It'll confuse everyone.
That's great. I love that.
You put your hyphen on it, you know.
Oh yeah,
Biedrzycki Smith.
Despite my traditional ways, I think I would understand wanting to keep the maiden name.
That's great.
Awesome.
My wife's from Texas, and she took the last name. And based on what we talked about earlier, because it's probably not that common of a last name in the U.S., maybe it is. Don't Google Bobby Biedrzycki if you're in Chicago, right?
No, you don't want to. I am not affiliated with anyone in the city of Chicago with the same last name. So,
man. Well, we're excited to talk today. We're talking about cactus water. Brett, you wanted to have this conversation really specifically. Why don't you kind of introduce us?
Yeah, so I mean, water with especially here in Texas is a big deal, right? And produced water specifically has been the subject of litigation since the Permian really blew up, and companies and operators evolved and advanced their use of wastewater, traditionally wastewater, and essentially they've turned that wastewater into a viable, product that they can reuse, market, sell, extract things from, and all of this kind of produced lithium through produced water and salt water and brine, and then all the work, the refrac work that happens, the recycling of produced water. It's just becoming more and more of a thing that as a landman you need to really understand. And so I was reading through the kind of the top cases of the year in the most recent Landman magazine, and it had this cactus water case. And just as I was going through it, I thought, well, how does that apply to, ownership of constituent minerals from produced water? And so I thought it would be just a great conversation to talk to Bobby. He published a number of really informative articles on cactus, that case, and the effects that it has, and just overall produced water. So he's a great resource for the landman community to kind of understand that and really dive into some of the nuances that you might deal with. And so figure we would start there and just really talk about that case and what we're seeing and some trends that we're seeing in produced water in the Permian Basin and Eagle Ford and things like that. And then maybe if we got some time, we can transition into how, the lithium space and extraction of lithium through brine and what we might expect there. There's a lot of questions up in the air as to how we should interpret that and just take it from there. So that's what got us here. We want to revisit it a little bit.
sure. Yeah. Glad to talk about it.
So can you just give us a general rundown, Bobby, on this case, on the cactus water case?
So cactus water is coming, and really kind of the part that's interesting for us is the part that's coming out of the Court of Appeals in El Paso. This is a case out in Reeves County where essentially Concho as the mineral lessee under about 37,000 acres, and it's across 3 different leases that are kind of controlling. And then this company called Cactus Water comes in and does essentially a produced water lease on top of that. So these are leases that are about a decade old when this kicks off, and then Cactus Water comes in and leases same kind of 37,000 acres, and essentially it was, we want to pay you a royalty on your produced water if and when we can monetize it. And this is really one of the, I don't know either side, the parties in either side in terms of like personal relationships there, but it seems like one of those cases where sometimes you are effectively buying a lawsuit, and it seems like that's essentially what Cactus did in this case, is to go in and challenge some of these rights. But Cactus's position was, water is historically been a surface element. It's something that belongs to the surface estate owner. These leases leased the oil, gas, and then in one of the leases, it was oil, gas, and other hydrocarbons. And then another one was just simply oil and gas. Their position was, that's not water. It's not water of any form. And so we're going to lease on top of that, and then try and monetize that produced water as it becomes a more necessary resource, and as technology continues to advance to treat it. Ultimately, it went up to the court of, competing summary judgments got filed in the trial court. They found in favor of Concho, goes up to the Court of Appeals, and 2 of the justices in favor of Concho and affirmed that decision. And then one of the other justices, Fox, filed a pretty lengthy and respectful but scathing, basically saying they're wrong. No, this belongs to Cactus. This belongs to the surface owners. And then we're just kind of waiting to see if and when the Supreme Court's going to take it.
So Cactus Water secured their leases. And who sued who? Did Cactus Water then immediately sue Concho to say, hey, we are entitled to access to your produced water?
Cactus put Concho on notice and effectively said, we're entitled to your produced water. You're taking our rights under this agreement. And then I believe it was Cactus that filed suit first. They filed what's called a declaratory judgment.
Okay.
And so we have these competing documents, and we want a court to interpret them and to determine what our rights are under both of them.
Okay. And so as far as the results, you had a 2-1, and now it's being considered by the Texas Supreme Court as to give a final judgment on it.
Kind of. So in Texas, not too dissimilar from in federal court with the United States Supreme Court, there's very limited automatic rights to appeal when it comes to the final Supreme Court. So 2 justices found in favor of Concho, 1 dissented, but because it's 2-1, the lower court's decision was affirmed. Concho wins, and then you have to file what's known as a petition for review with the Texas Supreme Court to see if they'll even
take the case,
even take it. Yeah.
So, Bobby, what this means, just to kind of summarize on it, if this holds, if the Supreme Court doesn't take up this case, if it would leave us all with the understanding that if you are an oil and gas operator that is producing, that you have the executive rights to monetize, to do whatever you need to do or can potentially do with that produced water. And if
I wish that was true.
Okay.
And so within the legal space, it gets a little bit confusing because technically, if the Supreme Court doesn't take it up, then yes, that is the decision in the El Paso district. And so there will be controlling precedent there, but that's not necessarily going to be controlling in other areas. So it wouldn't be controlling. It's informative, and it's unlikely that lower courts would go against it, but it is only, it's informative, and it has some value, in East Texas, where this is going to be a huge issue with all the brine extraction. But until we get an official Texas Supreme Court ruling, there's not going to be any uniform law across the state.
Is there discussion in Austin about addressing this legally, by law, defining this?
That's the problem as we kind of see it, is that it has been defined in Austin, but I think they got it wrong. Not that anyone ever gets it wrong. But that's part of the issue of what didn't get addressed in Cactus that we were really paying attention to, that we were interested in is, produced water. And I think this is kind of the story I always tell with produced water. Before I went to law school and became an oil and gas attorney, I actually had a services side business in the oil and gas business. And I was kind of just faking it till I made it and trying to figure out what was going on and where things were going. And it was on we were in like the alternative power section. So, when you needed to bring SCADA systems online, chemical injection pumps, we made the batteries and the solar panels and all of that to go out on those well sites. But I didn't know a ton about the industry in terms of the oil and gas industry. And this is, 10 years, 15 years ago. And so you're learning the lingo and you're learning how things work. And I remember being out with a tool pusher in Alice, Texas, and we're trying to sell some product and move some product around on this well site. And he keeps going, he keeps talking about the monkey cage. And so there's monkey cages over here and we're installing monkey cages over there. And we're doing this with the monkey cage. We're doing that with the monkey cage. And I'm nodding my head, just trying to get a sale. And I remember getting in the truck with my business partner afterward. We're going down the road. And I said, man, I'm sorry. I know where the pigtail is. I know where the mouse hole is. I know where the rat hole is. I know what the Christmas tree looks like. I know what happens when we nipple up a well. I know what happens when we nipple down the well. Where the hell is the monkey cage out here? And he pulls over and starts laughing. And he just goes, he's like, man, we're in Alice. And there's a monkey farm here, and his brother-in-law built the cages for the monkeys. And he just said, thank God you didn't open your mouth out there. And I always like to tell that story where we're talking about produced water, because that's the problem. Is what is it? Because sometimes we call it produced water, and sometimes we call it flowback water, and sometimes we call it brine water, and sometimes we call it salt water, and sometimes we call it groundwater, and sometimes we call it a million different things. And the problem is the legislature keeps moving those terms around and throwing terms of art into some of the legislation that doesn't actually track. So if you look at like the House bills that came through in 2013 and then I guess in 2018, they've defined produced water as fluid and oil and gas waste, but the Texas Water Code defines groundwater as water percolating below surfaces of the earth. That sounds like brine water to me. That's out these things that are already there. And so what is it? And so I think we've really created this big headache. And it's going to be interesting to see how we sort over the next couple of years.
Yeah. So specific to the Permian Basin, and then that El Paso district, what potential effect does that have? We know there's a lot of value in repurposing this water, repurposing frac water, extracting, using water from extracting salt from the produced water to use for fracturing and things like that. Has it caused some major rumbles out there with some of these companies that are trying to really monetize that? Or
I have not seen that yet. I think it's coming, and especially as lithium becomes a bigger issue. And obviously with the monetization there, because within this definition of fluid oil and gas waste, they're also defining brine water. And there are these competing definitions there where, and to be clear, I think the legislative intent behind this was really, really good. For years, this is like produced water has been a liability, and it's kind of competitive liability. Who wants it? And so the operator has always taken this and has always disposed of it. The problem is, as technology has advanced and we're able to treat this better, water and potable water becomes a increasingly diminished resource. There is a need for more and more produced water to either be injected downhole for fracking, or where we can actually treat it to the point where we potentially drink it.
Yeah. That's hard to even imagine, but it's technology is going to advance. It's going to get better. We're going to become more sophisticated with our use of this product. So I know we all want to try to get ahead of it. And you touched on lithium. It's a good segue, right? Or lithium probably won't be the last of our ability to extract and monetize things. So what are we foreseeing in your space? And obviously there aren't any, you clearly stated that there aren't any definitive clear rules on this front, but what are we anticipating when it comes to, if we have these oil and gas producing areas, we have this wastewater, and it also is deemed to be, potentially lithium rich. You mentioned East Texas earlier. What guidance are you guys giving your clientele that may reach out to you guys on this front about how they should handle if they're trying to put together a lithium play or, something like that? How do they handle HPP leasehold and active production and maybe obtaining that, working out deals with working interest owners, to have access to that water?
Sure. So a lot of it stems around, and you mentioned if it's held by production. So I'll briefly touch on, if it's not held by production, if we don't have an active oil and gas lease out on this property, the nice thing about what the legislative process looked like in, I think, 2018, when they amended this bill, is that they did create a specific provision in there for carve outs for oil and gas leases. So the number one thing I'm going to tell a client, especially if there's not, there's not production, there's not on it, is we need to deal with these issues in a lease. Whether you're an operator, whether you're a landowner, you've got to deal with these issues in your lease to say, this is how we are going to treat these things. And that was part of the issue in Cactus, is that they hadn't defined produced water. They hadn't defined water. They had one of the leases talked about oil, gas, and hydrocarbons. And then I think the two other leases just said oil and gas. The issue then, if you're under a lease, you need to look at your lease, because some of it is, sometimes in our leases, we'll see, it's a lease for oil and gas. Sometimes it's a lease for oil, gas, and other hydrocarbons. And then sometimes we just track especially older leases, we just track the reservation language of what we saw in the deeds, and it'll be oil, gas, and other minerals. And if the lease is for other minerals, that's where we get into these issues of like who actually, like what constitutes other minerals. And in Texas, I wish it was more clear. States like Arkansas, so where there's a lot of brine production for bromine, over in the Smackover plays, they've dealt with this because they've been dealing with these issues from the 1950s on. And so they've created legislation and they've really well defined it. In Texas, it's not quite as clear. And there's actually somewhat of a line of demarcation in terms of when the reservation occurred. And I think the date is like June 8th of 1983, where we moved away from what was the surface damages test as to what becomes, or we call the surface destruction test for minerals. And then we moved into an era where we started looking at the intended purpose and the language behind it. And so a lot of it's going to depend on what era and what age your lease is.
Yeah. So the takeaway is gather as much information as you can, and you have to analyze each circumstance almost individually.
Yeah. And you're looking for, I think, especially just as practical takeaways for folks, I think you're looking for certain language. That other minerals word is really important in any kind of, whether it's a lease or whether it's a
conveyance
or whether it's
document.
a conveyance. Yeah.
Yeah. So, I mean, I think East Texas, I think leases in general, we bought gobs and gobs of them over the last 20 years here in Texas or throughout my career. And, oil, gas and mineral lease, you see it pretty commonly, in a lease form. 10 years ago, 15 years ago, landowners started to more and more often do hard minerals exclusions from their leases. The intent being, hey, this is just hydrocarbons. It's a hydrocarbon lease.
Right. Right.
Are there circumstances where, for instance, you have that traditional oil, gas, and other minerals lease that does not have a hard minerals exclusion? Is it safe to assume that potentially that could be those lithium rights from that produced water, since is that considered a hard mineral? So is it safe to assume that if they didn't exclude hard minerals from their lease, that you would need to work out a deal with the working interest owner of that lease?
Yeah. And I think I want to just to nuance it a little bit. When we're talking about oil and gas leases, it's not so much of an exclusion as much as it is a direct conveyance. So that's what we see in cases out of like the 70s and 80s in Texas, of like whether it's an express conveyance, like you have to so if your lease is oil and gas, my argument will be that does not include other minerals. So the landowner doesn't necessarily have to exclude those things out and hold those things back. They have to expressly convey them, the mineral interest owner. If your oil and gas lease says oil, gas, and other minerals, I'm certainly going to argue that when you're conveying the other minerals, it's all other minerals, except for those that have been carved out. And so there are certain elements we said those still apply to the surface estate. Caliche, limestone, those elements, we've dealt with those.
Yeah.
The big
could be the source of why we would see those exclusions, leasing a mineral owner that also owns the surface. That became, a thing that they were informed about. Potentially you had oil and gas development, oil and gas operator would try to, extract rock or caliche from land because they said they had the rights to it in their lease. So I think that's what we really started to see that start to show itself. But, as you start applying these new things, you're like, gosh, who owns these rights? How do I secure those on behalf of my client? I'm doing it.
Well, and
whatever.
And remember in Texas, you've also got to deal with, if you're a surface owner and you just have the surface, you've got to deal with the accommodation doctrine. And so that, the mineral estate is that dominant estate. And so they have the right to use so much of the surface as is reasonably necessary to produce those minerals. But that's where we run into another issue with some of the legislation that's come out, because that right it's a usufruct right. It's not a conveyance and it's not ownership. We're not saying that oil company, that operator has the ownership of the water. They simply have the right to use the water. What this legislation has come in and done is they have said, because, and imagine, this is the scenario I like to paint, is like you go drill a water well out there, you're the operator, you go drill the well and you're going to go inject and use it for fracking or for water flood or for whatever. You're allowed to do that. But you're allowed to use it. It doesn't mean you own it. You own it. And so some of the legislation comes in and goes, but once it comes out of the hole and it's produced oil and it's produced water and it's liquid oil and gas waste that's been defined, it's a transition and it's a conveyance within the legislature. It's like landowner didn't convey that. They didn't give a right. And so now we're looking at what would be a Fifth Amendment taking violation. And this violation on constitutional rights. If you've taken my rights and you've given them to someone, and you've taken something that belongs to me as the surface owner, and you have given it to this other person who hasn't paid for it.
And who gets, even if they did take it, who gets paid? So if they have monetized it by extracting lithium or whatever hard mineral might be, we may discover in the next 20 years that we can extract. Who gets paid, and what are the terms of that payment? how do you access those rights? I think the takeaway is that we know it's an issue. We don't know the answer. Clearly.
Yeah.
Well, that's
I
just
know
awesome.
what's the legal answer always is it depends.
Yeah. Yeah.
What's the realistic timeline that you think this will be resolved? Like, how quick is it going to move or not going to move?
I mean, in terms of like timeline with the Supreme Court, I think this is something within the next 2 years.
Okay.
We see whether they're going to take it, and then we see whether it go. If they take it, then they're going to ask for briefing, and then you're probably looking at 24 months there. Now, the issue with the Supreme Court though is they're just going to look at, they're confined to the actual case.
Yeah.
And the way this
Yeah.
case got decided is because of the unique granting language in the lease. So they didn't discuss that. They discussed the House bills and they discussed the legislation that's out there, but that's not the basis of how they define their decision. And so, not saying that the Supreme Court wouldn't address it, but then you would have lawyers who will certainly argue that it's dicta, that it's not actually the issue in the case that's being decided there. It's just the Supreme, they might opine on how they think the legislation should be resolved, but doesn't actually impact it.
Do you think that another case would pop up in another part of Texas before the Supreme Court rules?
I think that's going to happen.
Okay.
The reality is what we're seeing is technology is advancing so quickly with our ability to treat this water. And they were doing tests with the cotton crops well over a decade ago, where they're saying like the treated produced water is able to be put into agricultural use for cotton, and you're getting similar cotton yield from it. And so in that kind of scenario where you're not having people, it's not being consumed by wildlife, it's not being, not potable water at that point. Why wouldn't we use it for those kind of purposes, especially as potable, and fresh water is diminishing.
Especially in the parts of Texas where there's not a massive water table. You're talking about desert conditions. Water is a valuable thing. And obviously that's why these companies like Cactus Water and all that are trying to seize opportunities to take advantage of all this water is being produced and the market for it, things like that.
Well, and you're going to see it also in the sense that I think it is inevitable that there's going to be greater and greater legislative action requiring operators to use produced and recycled water in order to drill, frack, complete, and recomplete wells. I think that's coming as fresh water continues to diminish, and it is a necessary resource. I think the requirements on reuse of water are going to increase. And so the value of that produced water is going to increase. And the scenario I always like to paint for people is that we've talked about it in the sense that it's going to help preserve fresh water and preserve and prevent the usage of fresh water under, the accommodation doctrine and their ability to go get fresh water. I actually would argue that it's probably going to increase our freshwater usage as we get closer and closer to requirements to use more produced water. And the reason why is because of the legislation that we have, where it actually allows where before it's a right to use. Now they're saying if you inject it down whole and it comes back up, which we know it does as produced water, it becomes yours. And you can do with it as you want. So why wouldn't, as the requirement is going to be to use produced water, why wouldn't operators use as much fresh water as they can that then becomes their property and their right to use in the future?
That's deep, Bobby.
It's really deep. Just spinning.
I don't know if I know more or less right now. I guess the takeaway, this is a complicated thing, right?
Yeah.
And there are no certainties. There are no assumptions. The main takeaway is proceed with caution. If you're dealing with water, if you're representing a client or working on a project as a landman that involves brine or access and use of produced water, recycled water, you need to make sure that you've got good counsel. You need to make sure that you've gathered appropriate information to be able to make an informed decision and really look through the unique circumstances that apply to your given situation. Other takeaway, we've still got a number of years before we probably have some clear guidance that will help define the rules of the game when it comes to some of these things from the courts. I think we're going to have a case, and then there's going to be another case that's going to address a situation, and it's just going to have to work itself out. It's relatively to your point earlier, technology has changed the way we have to look at all this, and you can't make any assumptions anymore.
That's right.
It's going to have to, you hear it all the time, right? When we as landmen reach out to attorneys, well, the courts are going to have to work this out. And that's applies here more so than anything I've seen in quite a while. There's going to have to be a lot of back and forth before we start to get some clear guidance on how we might handle these situations.
Yeah, absolutely.
Yeah.
Does this slow down the progress we can make on lithium, or are people just going to keep moving and shaking and trying to get deals done regardless?
I think they're going to try and get deals done regardless. You see it all the time where people are baking litigation costs into their purchase price. Like they know there's going to be a fight. And part of that is why, especially for companies that are acquiring these, I think it's so important to have not just counsel who, in the legal space, we talk about, litigation versus transactional counsel. And I'm on the litigation side. I have to do the transactions, just because it's part of most settlement agreements, and that's how I learned to do those. But I'm on the litigate and fight side, and I always joke around because some of your transactional guys will be so wired up on like, this is how it should be written. And this is how it's like, if we write it this way, no one's ever going to pull it apart. And it's like, that's cute. You're going to have that
Hold my beer.
that agreement that you spent hundreds of hours on putting together. There's going to be some first year lawyer, who tries to pull this thing apart and might succeed.
Yeah.
And because the question is just, what kind of numbers are we talking about? And when you start getting into some of the increasing value of this, someone's going to come try and take a shot at those agreements. They're going to come try and take a shot at the legislation. They're going to do all of that. And so I think it's really important, especially on these deals where there is some level of uncertainty of how it's going to be handled, that you not only involve really good counsel at the beginning to help you draft your agreements and look through your agreements, but also have counsel who's ready to try the lawsuit. It's not uncommon in deals like that where we are structuring deals from the beginning, anticipating litigation and thinking this is going to put us in the best position when we do go get challenged on that.
Yeah. Well, man, all this tells me is that we're going to have to talk again in the next 2 or 3 years.
Yeah, absolutely.
So what is the best way for people to stay up to date with this information? Obviously, we know that our podcast is followed by millions, and people come here
Billions.
for all the
I think billions. Yeah.
all their information. But where can they stay in touch with this information?
I mean, there's a lot of in terms of produced water right now. We have a number of articles through our firm's website with jacksonwalker.com, jw.com.
jw.com.
Yes. And so there's a number of articles, I think, and they always have funny names. What is my produced water payment is like the future tidal wave of litigation. And Reagan and Pete just put an article together about Lie to Me, which is LI for lithium. And, the things that we stay up late at night thinking of how cool we are. So there's a lot of great resources out like that. This is just there are plenty of, I think, mineral rights, other podcasts. There are plenty of channels that I look to. Sad to say this, but YouTube is one of my greatest resources when I'm coming in.
Man,
Don't be sad.
Dr. YouTube is the best, man.
Yeah.
I mean, just like when it comes to technology, if I need a simple explanation of like, they're getting the what out of the water, like that's where I go.
Yeah. I mean, I've started using AI and chat and all the different large language models to gather information, especially if you're looking for high level, kind of like what's what in this state? What have we seen in that state? And you can get a lot of information. Obviously it's not legal counsel, but it helps maybe point out circumstances in a certain area that might be unique. So
Sure.
yeah, awesome.
Yeah. Very cool.
Bobby, thanks, man. It's a complicated topic.
Of course.
It's got to eat you alive to not be able to give kind of like definitive guidance, but the takeaway is it depends. So call Bobby up.
It's going to, there's going to be a lot of back and forth over this over the next couple of years. And so, my best advice always is if you can deal with it in your agreements and if you can carve it out and get specific in your agreements, you always should.
Yeah, absolutely. Well, thanks again, Bobby, for being on. We really appreciate it. And we'll have you on again sometime to talk about monkey cages. So,
man, I'm an expert on that now.
Awesome. Take care, man.
Take care, guys.
Thanks for listening to The Land Department. Check out our website in the show notes or visit dudley-land.com to learn more about us.